Would like to mention that in addition to being an associate at Rudnicki and Company, she is the Director of Advocacy for the Canadian Association of Black Lawyers. Given the proportionate impact or disproportionate impact of unfair laws can have on marginalized people, this is an important and welcome perspective, and we're glad that Teresa is here to help us cover that off. Teresa, without further ado, I'm going to pass the microphone over to you. Thank you.
Great. Thank you, Catherine. It's great to see so many people online and interested in this important topic. As I'm sure many of you are aware, Canada's bail system is a hot topic of conversation right now, with the Ontario government calling for the feds to get tougher on our bail laws. And we've heard a lot about how there are calls to get rid of this catch and release system. But for those of us who actually work in the criminal legal system, we know that there's far from a catch and release system. We know that there's no empirical evidence that the proposed bail reforms will actually make our community safer. We know that the evidence shows that actually around 80% of incarcerated people in Ontario jails are legally innocent awaiting trial. We know that the evidence shows that Black and Indigenous folks continue to be over-incarcerated, denied bail more frequently, and experience harsher conditions of confinement. So the goal in the next hour or so is to really debunk the myths and have a candid discussion about the real problems with Canada's bail system and how we can address these problems in a way that both protects the rights of accused people and keep our community safer in the long run. We have three great presenters for you guys today. Just as a heads up, we will be leaving time at the end for questions. Feel free to throw your questions in the chat, or you could wait till the end and use the raise your hand function to ask questions. With that said, I'm going to introduce our first panelist, who is Abby Deschman. Abby is a lawyer at St. Lawrence Barristers PC, and she's currently serving as the Interim General Counsel and Executive Director of the Canadian Civil Liberties Association. Abby has extensive experience pursuing systemic reform and legal change outside of the not-for-profit sector. In 2017, Abby was a corrections advisor to the Independent Review of Ontario Corrections, investigating and writing reports into solitary confinement and the operation of the provincial correctional system. She then went on to serve as senior policy advisor for the Minister of Community Safety and Correctional Services from 2017 to 2018. So I will cede the floor to Abby to present for about 15 minutes on the topic of bail reform.
Great. Thank you so much, Teresa. I do have a slideshow, Henry. I didn't send it to you, but let me see if I can just present it.
Any luck?
It's coming. There we go. Okay. There we go. So thanks, everybody. It's a real pleasure to be here. I did a lot of work on the bail system as CCLA's director of the criminal justice program many years ago, and so I've had the opportunity to collaborate actually with both Nicole and Jacqueline for many years. And I will say I have missed the opportunity to talk about the bail system since I've been doing more private practice. And anyways, it is lovely to be back again speaking about bail and pretrial detention. What I'm going to try and do in my 15 minutes is really give a lay of the land background. I know we probably have a mixed audience here. For those of you who may be criminal defense counsel or work in the bail system, some of this will be old news to you. But I think it's important to start at the beginning and really set some of the groundwork for the further discussions about politics and more recent research that Nicole and Jacqueline will bring. So we're going to talk about the law, the reality, and the impacts of the current system. This will draw quite a bit from the research that CCLA did in collaboration with Nicole Myers, both in 2014 and in 2024. You'll see that peppered throughout. So the law of bail. The law of bail is actually incredibly straightforward as criminal law goes. And it draws from both constitutional and statutory terms that are really clear, right? So everybody in Canada has a constitutional right to the presumption of innocence. And when people come into conflict with the law, when they are having their bail set, you are in the pre-trial phase. You have not been found guilty of anything, and you are presumed innocent until you are either found guilty by the court or you plead guilty. The other constitutional presumption is a constitutional right to reasonable bail. Right? That is set out in the Charter. Reasonable bail means that you are going to be released at the earliest possible opportunity. You are going to be released presumptively unconditionally while you're waiting for your trial. You're going to be released with presumably no supervision while you're waiting for your trial. And any more restrictive forms of release, any more restrictive types of supervision are going to have to be justified. They're going to have to be justified under the Constitution by the government. And also the criminal code now very clearly sets out provisions that say, yeah, the Crown has to prove in most cases why you are not just walking out of that courtroom with a instruction to appear for your trial down the road. We call this the ladder principle, right? So the ladder principle in the bail context is the least restrictive form of release with the fewest conditions placed on an individual's liberty is the starting point. I will say we do have now increasingly reverse onus provisions. So sometimes people can be charged with certain types of crimes or have certain types of criminal histories that turn this on its head and require them to prove why they should be released. But for most people entering bail court, it's a presumption of unconditional release. And that is because people are presumed innocent, right? They are not in bail court for punishment. They are not in bail court for behavior modification. There's 3 things that the court can pay attention to when they're considering whether a person is going to be released on conditions, or held until their trial. And that's what these grounds of detention are. So we have primary grounds of detention, which just means, are you going to show up for your court date? If there are concerns about whether or not you're going to show up, then the court is going to have scope to impose either some supervision or some conditions. Secondary grounds of detention, think about public safety. So is there a substantial likelihood that you're going to commit a crime while you're out on bail? Or is there a substantial likelihood that you're going to intimidate another participant, a witness, or a victim? And then tertiary grounds, much less commonly invoked, are about disrepute to the administration of justice. So in that case, you're sort of thinking about a very high profile, very concerning allegation against someone and overwhelming evidence that, yes, this person committed that crime. Those are the types of facts that might, if you were released, bring disrepute to the administration of justice. Most people, though, are focused on, are you going to show up for trial? And is there a substantial likelihood that there's a risk to public safety if you're released on bail? So all of the bail decisions have to be tied to those concerns. It is not about, for the vast majority of people, it shouldn't be ever about punishing you. It shouldn't ever be about modifying your behavior or trying to change some underlying social conditions. It really should be showing up to trial, public safety, and exceptionally, disrepute of the administration of justice. If the court has concerns about any of those 3 grounds, then they can start to ramp up your bail conditions and your form of release. So you start out in your form of release, this is the presumption again, with no financial obligations. You're just going to promise to come back to court when you need to for your trial. If there are some concerns, though, that, you may present a public safety risk or you may not show up to trial, then you can have more onerous forms of release. So that can include a promise to pay, or sometimes that's called a recognizance, where you promise if you violate any of the conditions or you don't show up to court, you might be pursued for a certain amount of money. A surety is a higher level of supervision. That's where usually a friend or family member in the community promises to supervise you to some extent and can lose their own money if you do not abide by the conditions or show up to court. And then there's a cash bail, which it should be very exceptional in Canada, and requires a person to put down money in order to secure their own release. So those are the forms of release. Maybe Jacqueline will talk more about bail program. That is one form of release that people are subject to. But they increase in stringency, and the latter principle says you start at the lowest release with no financial obligations, and then you discard that if that's insufficient to meet the whatever grounds are provoking the concerns in the individual's case, and you work your way up the ladder. But you shouldn't jump rungs, right? You need to start at the bottom. Conditions of release are also frequently part of the bail discussion. So a condition of release is basically a rule that a person has to abide by while they are out on bail. And it can be everything from you must reside at this particular address to you cannot leave your house after 10 p.m. You are under complete house arrest. It's a long and broad list. Legally, though, those conditions all have to be as minimal as possible, and necessary and tied to the concerns for the grounds of detention, right? Is it because you're worried this person won't show up to court? Well, then maybe you need to report to the police your address. So if they don't show up, the police can go out and look for them to ensure that they do return to court, right? There has to be some logical connection between the condition you're imposing and the legal concern that is giving rise to the authority to impose these conditions. And we have a series of Supreme Court cases that are excellent in really setting this out, right? So I'm not going to go through all of them. They're listed in these slides. Some of them are. But it really, a series of Supreme Court cases over the past 10 years has really drawn the thread between the presumption of innocence, the purposes of the bail system, the fact that you do have a constitutional right to reasonable bail, and what this means for people, both in terms of the timeliness of the bail release, the types of supervision they should be subjected to, and the types of conditions. And it really does paint a very clear picture for everybody that is involved in the pretrial decision-making process that the constitutional presumption is release with no conditions, right? That is what should be happening unless there are specific reasons to depart from that presumption. So that's the law. It has been actually, we have had legislative reform over the past few years. I would say that legislative reform has not changed, has not introduced major changes to the law of bail. This really has been the lay of the land legally for many, 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 many decades, right? We have not had major legislative overhaul in the bail area since the 1960s. So it should be a pretty stable picture about what's happening. So what is the reality? And I think Nicole and Jacqueline will get into this as well a bit. So I'm gonna try and not duplicate them and be brief. But this is one of the things we need to have in the background of our mind. These are police reported crime rates, 1962 to 2023. You'll see I've just screenshotted this from StatsCan, but they show increase in crime and then a decrease in crime. And then, in the past 10 years or so, we're sort of decreasing a little bit. The light blue line at the bottom is violent crime rates. The dark blue line at the top is total. And we really are at a low point still, despite the fact that we had, some increases in property crime in the late 2018, 19, right? We really still are at a historically low point as compared to where we were 30 years ago in Canada for crime rates. So these are the crime rates, and you would think that crime rates are tied to incarceration rates. These are incarceration rates. So you remember that like mountain with a bit of valleys and troughs at the end point. Incarceration rates doesn't look like that, right? So these are provincial rates and federal rates from 1978 to recently, and it's pretty stable. We have a pretty stable incarceration rate, both federally and provincially. It is not tracking our crime rates. But these are overall incarceration rates, and they hide some concerning and relevant details. And here's where we really get to the bail system, because this is the graph that shows the rate provincially. Again, that's the blue one. That's the total provincial incarceration rate. And we have in the red, the incarceration rate of sentenced individuals. So these are people who have, again, either been found guilty and sentenced to a period of time in a provincial institution after a trial, or they've pled guilty. That has been decreasing. So we have been having fewer and fewer people as a rate that have been sentenced and are serving time in our provincial institutions. And then the gray is the remand rate. Those are people who are serving time before their trial. Those are people who are either formally detained waiting for a trial or are just waiting to make their way through the bail process mostly. And more people are in that category. So we really are increasingly imprisoning people who are legally innocent in this country. And there's different ways to look at it. This is a graph of the proportion of provincial territorial custody counts in remand. The lighter blue line is Canada. And you'll see that, again, over the past 50 years, a really dramatic increase in the proportion of people in our provincial jails and territorial jails that are for trial in pre-trial detention. We go from about 24% in 1978 to well over 50%. And in Ontario now we are at 80% of people in our provincial facilities are jailed before their trial. So what's driving this? Why do we have more people who are being held and jailed before trial as compared to sentenced people at the provincial territorial level? So this starts to draw into some of CCLA's reports. Remember the constitutional presumption of unconditional release and release under your own undertaking, a promise to appear. So that's really not happening in bail court. About half of all the individuals released on bail, and this is common. We did reports in 2014 and 2024 that drew from observations in bail courts. Nearly half of all the people released on bail were required to have some form of supervision in the community, whether a surety or a bail program. And again, that's like the third rung up on the ladder. We have in the past 10 years seen some decrease in the surety supervisions, particularly in Ontario. And I think that is a reflection of the increased attention that's being paid to the bail system. But we're still using some form of community supervision for the majority of people who are released on bail, according to our observations. And the most common form of release was the accused zone recognizance, but that's where someone has to promise money, right? That is not the least onerous form of release. The least onerous form of release is just a promise to appear, an undertaking. So we really are not seeing the bottom rung of that ladder being used in bail courts. So conditions also reflect that we are missing some rungs of this ladder. So in 2014, the people we sent out into bail courts observed 196 bail releases. Not a single person was released unconditionally. What that means, either you think that the police are making 100% perfect decisions about every single person that they decide to detain, because they also have the power to release people directly from their custody, either unconditionally or on conditions, in which case you don't make it to bail court. So either the police are exercising incredible prescient discretion, or we are not following the law of bail, right? Not a single person was released unconditionally. In average, 7 conditions were imposed, up to a high of 34 conditions. And then in 2024, still quite similar. Again, no releases where we knew the number of conditions. No releases were unconditional. And on average, 6 conditions were imposed. And these conditions, they vary, but there's some ones that are quite common across many different cases. So limiting where you can go, geographic restrictions, curfews, where you can live, no contact, usually with other people who are involved in the allegations against you, no weapons, abstinence conditions. Previously, we saw more treatment conditions and conditions to keep the peace and be of good behavior. Those have decreased according to our observations in the past 10 years. But really still a large number of conditions being imposed. And so what are the impacts of the system? So when you are brought into the bail system, it is not usually a planned occurrence, right? You are arrested. Very, very few people have noticed that they're going to be arrested. Some people do turn themselves in, but most people are arrested, brought into police custody, and the police decide to detain them, right? And most people are staying for days. Some people are staying for weeks, months, years. So what happens? You are missing employment, you're missing your payments, you need to find emergency childcare, you may have missed your medication. It really is an extremely disruptive influence, an event in people's lives. And it has an enormous impact on the justice system. So this is a chart that just helps illustrate what people are facing. So these are median days in remand in Ontario versus the median sentence that people are receiving. And 2021, you can see that if you're in pretrial detention, you're spending on a average 21 days in remand, and your sentence average is 24 days. So if you can imagine, you're sitting there, you're about to lose your job, you're about to lose your housing, and your lawyer says, well, it's going to take you, a few weeks, if not months, to sort out your release, or you can plead guilty. And then we'll probably get a sentence in the range of, a week or two, and then you can be released immediately. Sometimes it's you can plead guilty and walk out today because you're going to be released and supervised in the community, right? It is a factory for guilty pleas. Very few people sitting there in jail would rationally decide that they want to wait for, even to make it through the bail system, but definitely if you're detained, and that they want to wait for their trial, because the amount of time that you're spending in jail is just so disproportionate to the sentence that you'll be facing for many, many people. So it forces guilty pleas. And then the impacts, I think in order to understand the impacts, we need to also look at who is being brought into our legal system, our criminal legal system. So this is a very traumatized population. These figures are based on federal incarceration research, but half of the people in prison federally in Canada experienced abuse in childhood. More women than men. But still, a third of all men reported any sort of childhood abuse. Sexual abuse is very prevalent. Half of women in federal custody were sexually abused. Neglect, physical, emotional abuse, this is a very, very traumatized population, right? Which makes sense. We know that some of the things that push people into conflict with the law are histories of trauma, which can lead to substance abuse issues, which can lead to periods of unemployment, marginal, precarious housing, et cetera. All of those will tend to push people into conflict with the criminal legal system. We also have clear evidence that there's significant race-based disproportionate impacts and really discriminatory impacts. Indigenous persons, these are a bit old, these figures, but 2011, 2012 made up 25% of admissions to remand. They're about 4% of our population in Canada. And a third of people admitted to remand in Canada are Indigenous, so vastly disproportionate mass incarceration of Indigenous people. We also have some more recent research on Black men in Ontario's jails. So they are 5 times more likely to be incarcerated than white men. Black women are almost 3 times more likely to be incarcerated as compared to white women. And then JHSO research has highlighted, and maybe I'll leave it to Jacqueline, how disproportionately this population suffers from substance abuse issues, addictions, mental health issues, homelessness, etc. And so this creates a vicious cycle, right? So your forms of release are going to be harder for people to access if they have if they don't have a strong social safety net, if they don't have a job, they can have hard time accessing sureties. If you have a hard time putting forward a good bail plan and convincing the court that, yeah, you should be released, that can lead to lots of adjournments and delay, which again means more missed work, more lost housing. Your families as well are going to be impacted by this. And I won't have time, but there are some really fantastic quotes, just thinking about the community impacts and the broader legacy of colonialism and the impacts on families of having parents removed. And if you think about the proportion of Indigenous people that are caught up in this legal system and then the ongoing cycle of impacts on their families, it really does mirror what happened with the residential schooling system. If you come from remote communities, again, especially Indigenous people, you're going to have a harder time working through the bail system. And then conditions of release, right? Lots of times geographic restrictions mean that you don't have access to services. If you are told you cannot use substances or you have limits on drinking alcohol, then that is going to interact very poorly with people who have addictions. And then there's going to be socioeconomic impacts. It's just very hard to follow a whole bunch of extra rules when you are precariously housed or have underlying health issues. And then this is the end, sort of the background, but all of these factors really do set people up to fail, right? So once you are in the bail system, once those conditions are imposed, any failure to abide by those conditions becomes a possible further criminal charge. So if it wasn't illegal before for you to go to the downtown east side in Vancouver, if you're released on bail with a condition that you not attend that, geographic restriction, then if they find you in there, then that is another criminal charge. And you really do see people with dozens of charges, some of which are actual substantive criminal charges, but many, many, many of which are breach charges that are just layering on top and increasing the punitiveness of our criminal legal system in a way that is intensely disruptive to their lives and the lives of their larger communities and family members. So I think I have more. I will leave it there. The one last thing I will say is I do have lots of photos at the end of this presentation that we won't get to now, but just about the conditions in pretrial detention, because they are horrific. Pretrial facilities are much, much, much worse in terms of the both physical condition of the infrastructure for most institutions, as well as the types of services and programs that people have access to. Lockdowns are frequent and extensive. Access to healthcare is extremely difficult. It is just a very, very harsh punitive environment for people who end up there, and these are people who are presumed innocent. So maybe I will stop there, and then of course I'm looking forward to hearing what others say and welcome questions at the end. And I may have lost Nicole. I don't know. I don't see her on my phone. So Teresa, I'll go
She's
on
in
mute.
the meeting.
Oh, perfect. Great. Then it's appropriate I've lost her. Okay, thank you.
Thanks so much, Abby. That was a really great primer. We're already running behind on time because 15 minutes flies by. So I'm going to pivot now to Nicole. I don't see her, but I hear that she's in the meeting. So hopefully there she is. Hi, Nicole. I'm just going to give a brief introduction of Nicole. Nicole Myers is a criminologist and associate professor in the sociology department at Queen's University. Her work focuses on the pretrial detention and bail process, community supervision, conditions of release, court culture, social control, and punishment. Professor Myers has published numerous peer-reviewed academic papers about bail in Canada and internationally. And together with the Canadian Civil Liberties Association, Professor Myers co-authored the 2024 report Still Failing: The Deepening Crisis of Bail and Pretrial Detention and Bail, which is a follow-up to their 2014 study, which was called Set Up to Fail: Bail and the Revolving Door of Pretrial Detention. Professor Myers is a recognized expert in her field, and having appeared before the Senate, House of Commons, and her work has been cited by the Supreme Court in those seminal bail cases that we just saw, cases like Zora, Myers, and Antic. So I'm going to turn it over now to Professor Myers to give a 15-minute presentation on bail. Thank you.
Hi, everybody. I just want to confirm you're able to hear me. Yes, and you can see my slides. All right, it took me a little bit longer to get in here. So I do apologize. I didn't get to see what Abby presented. I think there's a little bit of overlap here, but that'll be some of the pieces I move forward with a little more quickly. So firstly, thank you very much for this invitation to talk to folks about bail reform. As was sort of indicated by Abby, our law on bail has remained remarkably consistent in a number of ways for a long time. And yet, despite some of these consistencies, we've seen very long-standing and deeply entrenched problems with our bail process. And as of late, I've sort of been seeing this stoking of the political flames. And what I've included here are a number of slides that capture some of the quotes from a variety of different politicians. And I've highlighted and read the areas to sort of draw your eyes most closely to. But we're starting to see increasing rhetoric around that we want to make sure that certain folks are not eligible for bail or parole. We're hearing slogans around jail, not bail, and revolving doors of criminal justice. We have accusations that violent criminals are being arrested one day and are simply turned back out onto the streets in very short order to commit further offenses. Premier Ford has indicated things about like throwing away the key for somebody, and there are accusations from the president of the OPP Association that we have a catch and release system. Now, these kinds of issues and comments continue as we move sort of down closer to sort of members of parliament, members of the provincial legislature, or more arguments around what we're seeing slap on the wrists, that we really need to get tough on crime. And all of this is then couched in concerns around public safety. And the argument or the suggestion being that if our law on bail was simply more punitive or more harsh, the members of the public would be more safe. There's also indications that jails are not supposed to be pleasant places, that these places are not as bad as much of the evidence indicates that they are. I'm sort of curious when it is one of these folks last appeared or showed up into one of these institutions and had a look around. I don't think anybody is looking around pretrial detention and describing it as a luxurious hotel. So I put all of this out here to sort of remind everybody of the political context in which we are at, where folks from policing, from federal government, from the provincial government are coming together, and these claims continue to sort of get more loud and more ostentatious and disconnected from the data. Some of the difficulties that we have, particularly as I sort of point out in this bottom quote here, is that though our violent crime has gone up marginally, it's a relatively small amount. And that while we absolutely want to be concerned about any increases in crime and threats to public safety, we do want to keep this in a long historical context and recognize that while there may be some increases in one particular year over a few years, that our crime rates really do remain at historic lows. The other things that we need to be mindful of when people are presenting data such as this is to ask questions about what these data actually represent. And what the concern here is the suggestion that individuals are being released on bail and going on and committing very serious offenses. But in this category, they have grouped together anyone who has been charged or suspected of a particular offense but has not been charged, and grouped together anyone who is released on bail, on probation, serving a conditional sentence, or as part of their parole. Now, again, we may be concerned about people doing things while they are out on release on a variety of court orders, but it is dishonest to connect this to people that are specifically out on bail when this is capturing a much larger group of folks. The last thing to point out is that in 2022, there were 882 homicides, and 71% of these were committed by people who were not on bail at the time. I say this to point out and to demonstrate that what we really want to be concerned about are issues around public safety, but the efforts that are being put forth here are not looking at the correct cause of the problem. So I do believe this graph was shown to you by Abby Deschman when she was speaking. So I will just briefly draw your attention back here. And this is a demonstration that our long-standing problems in bail, and that these have been slowly sort of creeping up and getting more sort of egregious as time goes on. When I first started studying this issue in 2004, 2005, it was the very first year where Canada could say that we incarcerate more legally innocent people in our provincial and territorial jails than we sentence to be there to serve a sentence post-conviction. And that was shocking to me. And yet, as you sort of follow these lines into contemporary times, we see that these issues have continued to get worse rather than better. Now, despite what you may have been told, if you're listening to what politicians are saying, you're listening to what the police are saying, we do not have a lenient bail system in Canada. On any average day, we're looking at over 16,000 people are incarcerated in this country at a time when they are to be presumed innocent. The remand rate, the rate with which we put people in a remand per 100,000 people in the population, has quadrupled in the last 40 years. Currently, across Canada, almost 73% of all the people in our provincial jails and territorial institutions are in pretrial detention. And in Ontario, this sits at a staggering 80% of the population. The other thing we might want to be thinking about is those who are going into custody, so simply being admitted, and that over 100,000 people were placed into remand in 2023, and only 45,000 were put into prison as the result of a sentence, either to provincial or federal custody. This indicates that there are a lot of people that are experiencing punishment at the front end of the system. Keeping all of this in mind at the time where it's critically important that we acknowledge that people are to be treated as though they are innocent rather than treating as though they are guilty until we find out what happened in the matter. Now, if we situate Canada internationally, sort of Canada sticks out as a bit of an anomaly in the sense that across the United States, the UK, Australia, and New Zealand, we have the highest proportion of folks in our pretrial detention population. Now, it is also important to be mindful of rates per 100,000. This allows us to make more meaningful comparisons across jurisdictions and across time. And that while the remand rate is certainly exceeded in the United States by quite a lot, the United States is not necessarily the most consistent predictor of what it is that we are doing in Canada, as we have a long history of following a different path, and the United States is long known for its history of mass incarceration. But the rate with which we use pretrial detention in Canada is higher than that which is being seen in the United Kingdom, and the rates that we're seeing in Australia and New Zealand, well higher than Canada today. These increases have happened relatively recently. Now, if we look at the bail decisions that are being made in Ontario, we can look at sort of a few different things in this particular table. And the first thing I want to explain to you, these are decisions that were made in Ontario in 2022. So this means that the case was resolved that year, and we're able to look back at the decision that was made at the bail stage. Now, in terms of those who are released on bail, about half of the people coming into Ontario's bail courts are ultimately released on bail, and about 3.6% have their bail denied to them. But rather importantly, and sort of hidden in this data, is that over 40% of individuals are in pretrial detention and never actually apply for their bail. So they haven't had their bail denied to them, but they nonetheless remain in detention until the resolution of their matters. Now, if we look then across this chart, I've demonstrated here sort of how many days they're spending, so how many appearances are being made, both at the bail stage and at the end. But if I take your eyes all the way to the end of the graph of the chart here with the presumptive charges withdrawn. And what we're then seeing here is that across the board, a lot of charges ultimately end in a withdrawal. And those who are released on bail, about half the time, all of the charges in their matter are withdrawn. For those who are denied bail, we see smaller proportions, but nonetheless, we want to be mindful that these are folks who spend time in detention, who remain in detention until their case is resolved, and ultimately have all of the charges withdrawn. Now, on the one hand, we can acknowledge that perhaps this is a really, this is a positive outcome. The individual has not been convicted of an offense. But we do need to be mindful that it takes a lot of time to get to this particular point in the decision-making process. And this means that a lot of people are going to spend time in detention and then never be convicted of the offense it's alleged they have committed. And others are going to be out in the community, subject to supervision, subject to conditions, creating opportunities to accumulate further charges for failing to comply, and still ultimately have the charges withdrawn. Now, when we're talking about bail and pretrial detention, the tendency is to focus on those who are detained, as this is a very obvious and clear, serious deprivation of liberty that has serious consequences for the processing of the case. But we also want to be mindful is that most people are ultimately released into the community, whether this is done by the police at the point of charge and arrest, or whether this is decided by the court. And most people also perceive that this release on the community is less restrictive than being held in custody. One of the difficulties is because of the deplorable conditions in pretrial detention is that most folks, not everybody, would agree to any set of conditions to be released into the community. The problem with these conditions, as already sort of mentioned by Abby, is that for some people it's particularly difficult to meet these requirements. They may not have a surety available to them. They don't have a stable address that they can provide. There are also those who are going to be supervised by bail supervision programs, and these offer a very helpful opportunity for folks who may not have a surety, but nonetheless come with additional concerns about supervision and conditioning. And I just point to some very recent work that's coming out by PhD candidate Alyssa LeBlanc that explores these issues a bit further. One of the difficulties with the conditions of release is not only that they are so numerous, but they're incredibly restrictive, sort of in and of themselves, but particularly as a collection. And generally speaking, have the tendency to criminalize non-criminal behavior, behavior that outside of a court order is not in and of itself a crime. And then they have to comply with these conditions for an uncertain or indeterminate period of time, all of which time are at the risk of accumulating further charges. The result is that what conditions do is offer not only try to control and sort of people's behavior, but also provides an additional avenue for monitoring, for surveillance, to see how folks are able to comply in the community. But these serious consequences for failing to adjust their behavior and align with the court order is a new criminal offense, thus creating a pathway back to further arrest, further charges, and not possibly further detention. And we have to acknowledge that all the difficulties that we see, both in terms of those held in pretrial detention and those released into the community, have differential impacts on marginalized communities, that certain folks are more likely to experience the most onerous, the most restrictive, the most intensive surveillance by the state, by the use of supervision and conditions in the community. So we're going to see folks who are Black, those who are Indigenous, people who are dealing with substance use issues or mental health difficulties. All of these folks are likely to experience the most difficult aspects, which in its own way, rather than helping, are very likely feeding them and having them become more entrenched into the criminal legal system. Now, as I sort of started the talk with by presenting some of the quotes that are coming out from different politicians, is this time and importance of bail reform. That there was an incident at the end of December of 2022 that folks are perhaps familiar with, and I won't go into the details. And there's been sort of a series of incidents since where particularly tragic events have occurred, and the allegations include somebody who was on bail at the time. Now, these have then been used to sort of bolster conversations about us having a broken bail system, about us having serious public safety concerns. And in no way do I want to minimize the tragedy of the loss that's experienced in these cases. But we do need to be mindful that when we're talking about making sweeping policy changes, that we think about what is happening in context rather than focusing our attention too closely on individual examples. The difficulty also is that politicians have sort of been emboldened to start speaking about their commenting on alleged offenses and legal decisions that are being made by the court. And I point here particularly to the case of Umar Zamir. Now, in the context of after this particular offense where a police officer was killed by somebody who was allegedly on bail at the time, the premiers came together and wrote a joint letter to the federal government. And then we start sort of hearing not just rumblings, but louder sort of calls around this jail, not bail, that it's really easy to get out on bail, that there is something fundamentally wrong with the law. And if we simply change the law, we're going to be more safe. The difficulty then is how do we go about doing this? And one of the challenges being a lack of very critical and important systematic data that allows us to answer some very basic questions we have about bail. But the result after this was sort of a move by the federal government to act relatively quickly to engage in some kind of law reform, to try to soften some of the perceptions that Bill C-75 was responsible for these threats to public safety, and that the government was seen as being responsive to these concerns. And so we end up with Bill C-48 that creates a variety of other reverse onus situations, and for better or for worse, this passes relatively quickly. Whether or not this is going to be something that we're able to measure and see any sort of measurable impact is certainly subject to question. But nonetheless, this is the kind of reform efforts that start to come forward. And then in the midst of this context, the provincial government also decided to create I'm stumbling over that word, the creation of the Ontario Ministry of Auto Theft and Bail Reform. Now, after these sort of things start coming forward, we then hear some more Ford's proposals, and indicates that these are specifically about bail reform. And these came out in October 2024. Now, as you look through, again, I've highlighted in red where I want to draw your attention. You would not be mistaken to be wondering what some of these have to do with bail reform, because they actually have nothing to do with bail reform, yet have been put forward as being part of bail reform efforts, including such things as restoring mandatory minimums at sentencing, removing bail availability for particular offenders, mandating 3-strike rules, creating additional restrictions on conditional sentences, adding more about ankle monitors, and removing credit from time that's been spent in pretrial detention on any of those who are sentenced to custody. So these notions around bail reform continue to become sort of louder and more sort of involved in what it is these reforms that are being put forward for. And what I would suggest to the group here is that all of these are misguided directions for law reform. We absolutely have problems with our bail system. None of them are being captured by any of these reform efforts. We do not have a problem detaining people. And I would say we can perhaps ask the over 16,000 legally innocent people who are currently incarcerated across this country if they think we had a hard time keeping them in custody. Efforts at law reform have also been targeting removing or limiting the discretion of certain criminal justice actors without limiting the discretion of others. The efforts have been to provide police with more tools, more opportunities to exercise the discretion at the front end, while providing less discretion for those who are making legal decisions in bail court. An intensive caution needs to be offered here that while we may think that it's important to have some parameters or some guardrails around how folks are exercising their discretion, we do want to make sure that there's careful oversight over how these decisions are being made, and be mindful of whose discretion is being limited at the extent of others. What we are doing, however, is creating a more risk-averse, a more restrictive, and more onerous environment, which we are setting up particular people to fail and become further entrenched in our criminal justice system. We cannot accurately predict who's going to go on to commit a serious criminal offense or criminal offenses generally. We do have some tools. Most of those are not used at the bail stage, and even those that are inaccurate almost half of the time. Creating additional reverse onuses is unlikely to help in increasing or improving public safety, and yet runs the risk of bringing more people rather than less into custody. Jails do not equal public safety. Any time spent in custody, even short periods, is criminogenic. It means it makes people more, not less likely to commit offenses. And the ultimate impact is that we have disproportionate impacts because not everybody has the same likelihood of being brought into the system, meaning those who are the most marginalized in our society are the ones who are going to experience the most restrictive and onerous and criminalized elements of the system. The result, however, is that people are serving their sentences before or often in the absence of any conviction. The outcome being that a lot of folks have all of the charges that they are facing withdrawn. And those who perhaps don't and are convicted may end up in a time-served situation where they've already served too much or just the right amount of time in custody before they've ultimately been convicted. The difficulty is that sentences then look artificially lenient or short by taking into account what has happened earlier on in the process. And what does this do to perceptions of the criminal justice system, perceptions of justice, perceptions that the government is serious about risk and public safety? And we're also reducing any opportunities to engage in rehabilitation when we are diminished sentences on the back end because of everything that we're doing on the front end. So what are we really doing? Though we might talk about this being about prevention, about public safety, we come back to questions about prevention of what? Or public safety for who? We're operating in is an experiment in punishment without the pesky burden of conviction. This is a social control exercise over the most marginalized folks in our community, where we engage in extensive pretrial monitoring and control. We assess their amenability and we responsibilize them for their own improvement, for accessing resources in the community. And all of this acts to put pressure on people to plead guilty to simply get the process over with. Or moving into a space of legal contradictions where we have politicians putting forward the ideas of reform that would be absolutely be contrary to the rights protected by the Charter. And we're setting up the scene for political interventions that make people feel scared. And when we make people feel scared, then we are able to justify a return to tough on crime policies, policies that cause harm, policies that are not effective, policies that will not make us more safe. The result then is what we're doing is we're using the pre-trial process as both the punishment as well as the trial. So if anyone was actually interested in public safety in the bail system, there's a few things that I think we can do. We need to be doing work that is evidence-based. There is this desperate need for national systematic data that can be analyzed by an independent third party. In order for us to evaluate what the problems are and to assess if any of our reform efforts are effective, we need to know where we started, how it's going, and where we ultimately end up. And this data needs to be analyzed by somebody who is not going to be mixing together a variety of different categories to portray a particular message. We want to have principled reforms, and this does involve bringing together all of the stakeholders in these questions to have a clear and honest conversation and understanding about what those principles are and perhaps what kind of guardrails we want to provide to those who exercise discretion. But this also means we have to support and encourage those who are making incredibly difficult decisions. They are going to get the decision wrong sometimes. Things are going to turn out badly sometimes. We certainly want to avoid that to the best that we can, but we do not have a perfect system. These are human beings making decisions with the best information they have available. We need to invest in legal aid. We have been taken so much money out of legal support for folks who are involved in the legal system, and we need to make sure that they have access to the type of important defense work that is readily available to others who may have more means. We need to support people in the community, reducing our use of pretrial detention to hold those only who are absolutely necessary to be there. For folks who are out in the community, rather than engaging in a strictly surveillance and monitoring exercise, how do we best support people to make sure that they can try to get through the pretrial phase without incurring any additional charges and further than that into the future? And finally, we need to improve case processing. In order to hold people accountable or punish them, our system is premised on this idea that we're supposed to convict them of something wrong first before we engage in some kind of punishment. And right now, our system is doing precisely the opposite of that. If we want, what we need to be able to do to the best that we can, and these are difficult things, so we want to be able to focus our attention on that which is most serious and most risky, and find an alternative way to hold people accountable who have committed or have allegedly committed much more minor offenses. Thank you.
Thank you very much, Professor Myers. I think you provided a lot of insight and helped debunk some of the myths that we're seeing quite frequently in the media. I know that some people were having issues accessing or viewing the slides. So just a quick reminder that after the session, the recording will be posted on the John Howard YouTube channel. And if you do want a copy of the slides, you can put your email in the chat. I know we're coming up close to 2 p.m., but I asked folks to just hold it a little bit longer. We have one more presenter, and it's just really important information that I think it's important for us to have the time necessary to really dive into these matters. So our last presenter is Jacqueline Tasca. Jacqueline is the Director of Partnership and Strategic Initiatives at the John Howard Society of Ontario, bringing over 15 years of experience in criminal justice policy and legal reform in government and the nonprofit sector. Serving previously as a senior policy advisor in the Minister's Office at Solicitor General and the Attorney General in Ontario, she held files relating to reform and bail, corrections, and criminal law. In her time at John Howard, Jacqueline has authored numerous reports and media articles on police record checks, mental health, criminalization, and bail, including an article in 2013 called Reasonable Bail. So over to you, Jacqueline, to finish us off on this panel discussion.
Thanks so much. And I know a bunch of people probably have to drop off at 2 p.m. So I'm quickly thinking about the best use of my time here. And I'm going to just see if I can share my screen. I do have a little deck. I'm sorry, I'm having issues with my Teams today. So let's see if it works. Oops, nope, it's not correct. Okay, Ria, do you mind sharing? Do you have my deck? Do you mind sharing it?
Yes, I will.
Thank you. Thank you. And if you, okay, so hi everybody. it's a pleasure to be here, and it's amazing to see how many people are on this call here to listen and chat about bail. And I really hope that many of you are able to stay on after in the breakout group so we can continue the discussion. John Howard Society of Ontario, we put out a research report in 2013 called Reasonable Bail. And CCLA put out one of their first big reports on bail in 2014. And then there's been a series of really impactful reports that have come out since. There has been a number of law reform pieces that have happened. There's been some policy change. And I'm super glad that Abby and Nicole went first because I don't have to go over any of the legislative framework anymore. I don't think I can control this, can I? No. Ria, do you mind just skipping ahead to the next? There you go. You can keep going. So I'm in the interest of time, I'm not going to go over the findings of reasonable bail. It's over 10 years old now. If you haven't read it, it's a page turner. Go ahead and read it at your leisure. But essentially, a lot of the findings are consistent on what Nicole and Abby presented. We could maybe just scroll down right to slide 13, Ria. Sorry. Because what I'll do is give everybody a bit of a teaser of some forthcoming research we're doing, which will sort of be more focused on finding solutions as we sort of move forward on trying to reform and refine bail. So I think it's fair to say, as people have identified, that there's a lot of conversation and concern around the bail system. It's probably also fair to say that most people involved in the bail system at any point aren't really happy with how the bail system is operating. And I think we sort of hear from all sorts of different voices for different reasons. So what we're doing currently, what JHS is doing in partnership with a couple of academics, Dr. Caroline, we can go right to the next slide, Ria. Sorry. Through funding from the Maytree Foundation, we did a review of all of the literature, great literature, academic reports in the past 10 years or so on bail. And we've collated all of the recommendations that came out of all of those expert reports. And we consolidated them and grouped them into themes or sort of buckets. And then we went out and surveyed a bunch of justice professionals and all sort of all professions involved in the criminal justice or sort of the bail process. And we're also doing focus groups, both regional focus groups and also some sector specific or profession specific focus groups to sort of round out those survey findings. But what we basically asked people to do is rank the recommendations in terms of what they think are most important. And then we also ask them for their open-ended feedback on what's still needed in order to move the needle on bail. Because of course, there has been a lot of change. There has been some legislative reform. Obviously, it was an overhaul of the law on bail, but there has been policy change. There have been, at least in Ontario, a number of investments that have been made. There has been expansion of the bail program. So why aren't we sort of seeing the changes we might have expected? And what have we seen that is working? And anyway, so if we could just go down to the next slide. You can kind of get a brief sense here of who responded. Oh, you can see that we had 106 respondents. A significant percentage of the respondents were police, but we also had good representation from social service agencies, others, academics, and various court actors. And we could go to the next slide. Sorry, I realize we're at 2 p.m. Totally understand people have to drop off. The slides will be shared. So we also have fairly decent geographic representation, and we can go to the next slide. Sorry. Okay, so overall, this is basically one of the key bottom lines. Overall, even across all of the different professions who work within the bail process or the court system, the top 3 recommendations that were selected were there needs to be greater linkages with social services to support wraparound supports for persons, the better use of the bail verification supervision program, and expansion of bail beds programs. So this was something that came out across basically as ranked as the top 3 needs and top 3 recommendations coming from all those who are sort of have a stake in the bail process. So, I mean, we're at 2 o'clock. Should I sort of pause there and then I can sort of I can sort of dive more deeply into our findings and actually, maybe if we go down to my recommendation slide, if you go down, keep going. And again, we'll share these so you can see. Oh, there we go. So the top, I think in terms from John Howard's perspective, yes, of course, there needs to be ongoing conversation about law reform in order to fix the bail system, and happy to chat more about that in our breakout groups. But some of the most promising practices that seem to be supported by both stakeholders and research is the expansion and expanded capacity of DVSP programs. And I realize I haven't even defined the bail verification and supervision program, but in Ontario, this is a bail supervision program that is offered by nonprofit agencies or transfer payment agencies. In other provinces, I understand that, bail supervision is done by probation, but in Ontario, it is delivered by organizations like Elizabeth Fry Society, John Howard Society, and others. And we have seen since the pandemic an increase in the issues around acuity, issues around the complexity of the mental health issues, substance use issues facing clients who are coming into the bail supervision program, much more serious charges coming into the bail supervision program. And we're not totally sure if this is a result of, the courts relying on sureties less or what exactly is going on. But the reality is that these programs are supervising a significant percentage of folks, but could be better utilized in terms of providing greater access to those who would be otherwise detained. Bail beds is another huge one. A lot of people, and increasingly so, are coming into corrections with no fixed address. One of the major issues around primary, secondary ground concerns is if a person doesn't have a residence, that's a flag. And so bail beds have worked well in the couple of jurisdictions where they have operated. And we just need more access to housing and dedicated housing for folks who are on bail, because if they have a no contact order, they can't return home, or if they have no fixed address, this is again going to delay a person's access to bail. On top of that, bail beds can wrap supports around people in addition to just supervising them or providing them a place to stay. And finally, pre-charge screening. We don't have time to talk about this at any length now, but I thought I would just flag that in certain provinces, before police can lay a charge, Crowns have to review, screen it, and sort of approve the laying of charges, which has been shown to sort of weed out and screen out a number of cases that would potentially end up in bail court and or just contribute to lowering the overall backlogs in courts. So I'll stop there and thank everybody. And sorry, I missed the first half of the presentation. And so, but feel free to ask me questions if you're in my breakout group, because I'm happy to unpack any of this.
Thank you so much, Jacqueline. I know that I had promised to save some time for questions, but I also want to make sure that we have time for a meaningful discussion in our breakout groups. Catherine, do you want me to take a few questions now, or should we just go right into the breakout groups?
I think if people are interested in continuing the conversation, I certainly hope that they are, we might just head into the breakout groups so that we get more opportunity for people to provide comments and more variety of opinions.
That sounds good. So I'll hand it over to you guys for the breakout groups.
So if you would like to stay and participate in a breakout session, please do so. Otherwise, I want to thank you all very much for attending. We very much appreciate that this is an area of great concern where there's some real scope to try and improve things for the people at the front end of our criminal justice system. And we will be in touch as we proceed to come up with some ideas about how best to do that. Thank you very much. Have a good day. And thank you very much, presenters and Teresa. That was terrific. Really enjoyed that.